Hey, Culminators, we're back, and I'm really excited about this because those of you who follow me have probably picked up over the years that I'm an old radio hand. You might not even know that I did my senior thesis in college on the topic of spectrum allocation and the Coase theorem. And today I am bringing on as a guest Brendan Carr, who is a commissioner of the Federal Communications Commission. Thanks for joining us.
Well, wonderful to join you here. And now that you brought up your old radio broadcast, I meant to tell you, Ron, we've been going back at the FCC over the tapes there. And there's some indecency violations that have been really racking up over time. But, you know, I'll give you the get out of jail free card for now.
I appreciate that. I guess technically I probably still have my license, which you remember you had to basically send in a postcard and you got back a postcard there. You had and I don't even remember what section it was under, but I loved doing radio, and I was obsessed with radio. But I also saw the folly of government regulation over what happened with the regulation of the broadcast spectrum. That was so much of American culture was affected by a misunderstanding of technology and where technology could go. And here we are now on the cusp or in the middle of a very similar situation. First, let's tell us a little bit about your background. How does a person become a member of the Federal Communications Commission?
Well, thanks so much. And obviously, it's a treat to join you. I've been a big fan of the work that you're doing, not just at the law firm, but on Twitter. Importantly, that's really a vital platform for communications right now. And I think people being out there speaking forcefully for free speech are on the side of the angels, even if it doesn't seem like it, based on ratios and replies. So thanks for everything you're doing in your personal capacity.
I hardly ever get ratioed. But you're right, though. It is amazing how many likes really, really inane tweets will get. Although I think that Mr. Musk is beginning to figure out why that's happening and how that's happening.
Yep.
But we'll get to that soon enough.
Right. I think you're right.
Okay. So
the FCC is an interesting place. I came to the FCC back actually in 2012. I just applied through the GS system, was hired by the then general counsel of the FCC, who later went on to work for Google, not too surprising. But I was just a regular civil servant there, had the chance to work eventually for then Commissioner Ajit Pai as a legal advisor to him. And then when he was made chairman of the agency by President Trump, Pai made me general counsel of the FCC. And I just absolutely loved that job. My background was in litigation. I did appellate work, clerkship, the whole nine. Really enjoyed that. And then I had the chance to put my hat in the ring to become one of the Republican commissioners at the agency, and did that towards the end of 2017. It's sort of been off to the races. Now, I came to the FCC because I assumed that what we did was we watched Super Bowl halftime shows and look for any indecency or wardrobe malfunction. I thought you'd show up at the building and they'd give you some binoculars and some tickets to the Super Bowl, but that has yet to happen. But nonetheless, it's an exciting place. We regulate, obviously, wireless, wireline. We have a $10 billion a year universal service fund, which subsidizes internet builds in rural areas, does telehealth subsidies, does low-income subsidies. And obviously, I think we should be playing a more important role when it comes to social media right now.
So first, let's explain why it is that right now, and probably never, the FCC has no legal authority over social media as such.
Yeah, it's interesting. When you look back at the various forms of technology, the older the technology, the greater regulatory authority the FCC has over it. In the newer technologies, we don't have as much regulation. I mean, obviously, radio is heavily regulated. TV is heavily regulated. To the extent anybody's out there sending telegraphs still, you probably have to have an FCC commissioner sitting over your shoulder right now as you type those away. It's so heavily regulated. But when you look at social media, there's just never been such a wide gulf between power on the one hand and accountability on the other. And it obviously doesn't fit neatly into the FCC's traditional regulatory buckets, except for the fact that Section 230 is in the Communications Act. It is Section 230 of the Communications Act, which we administer at the FCC. So I think the FCC should step in and clarify the terms of Section 230, and we can do so in a way that's very pro-speech. And I've been pushing that view for a couple of years. It hasn't garnered a majority of people at the FCC just yet, but I think it's important we do so. Now, other people have said that we should regulate social media in the sense that we should step in and block Elon Musk's purchase of Twitter. And that is something that the FCC absolutely has no authority to do. It's an absurd claim. So we don't have that type of authority, but we do have authority to interpret Section 230, and we should do it. But more broadly, Congress should step in because, again, this gap between power on the one hand, accountability on the other is unmatched. And the reason why I think this happened was Silicon Valley grew in power in a blind spot for Republicans and Democrats alike. For Democrats, particularly at the end of the Obama administration, there was an ideological mind meld where they thought the same way, their politics were the same. So they were happy with those people gaining power and control over speech on social media. For Republicans, for a long time, there was this sort of fundamentalist libertarian view that was sticking, particularly in DC, that said, wow, if a big corporation wants to do it, who are we to stand in the way? And I'm glad to see that a lot of Republicans, myself included, have moved away from that fundamentalist libertarian view and say, we need some common sense guardrail, because big government is bad, no question. That's the only entity that can put you in jail. But big corporations can squelch individual liberty. And I think there's a lot of conservatives now that are trying to step into that void and say, big government bad. We don't necessarily need big government solutions, but we need something to protect the digital downtown square today.
I absolutely. I mean, like you, I began, I had a much more libertarian bent, as you can imagine, reading writing about the Coase theorem. You see how bad the policy came out, and and how people were able to exploit their government licenses, and how poorly the subsequent re-slicing and dicing of the spectrum kind of went, because you already had these existing stakeholders. I mean, you mentioned the old technologies that have so much more regulation. The more regulation they have, and the older they are, the less relevant they are now also. It reminds me of when I was in law school and I was looking for part-time work, and for a short time I was working for the Santa Fe Railroad, writing legal memos about, I forget now what the agency was. I don't even think it exists anymore. They regulated railroads. It was so incredibly irrelevant. So, you could have stopped off and mentioned cable in between TV and the internet. Yeah. But I think it's a very odd thing, because people our age, more or less, I don't know exactly how old you are. I'm 59. You're probably a couple years younger than I am. We remember a world in which there were 3 networks, and there were a number of independent, stations on every TV. But basically, before cable, you had access to 5 or 6 TV sources of information, and no one ever wanted to watch UHF. It was worthless. And you had a handful of newspapers. People don't realize that there historically have been issues with regulation of newspapers and ownership of newspapers
by the FCC. Yep.
Newspapers have never been less relevant. TV is on the way out. People, with streaming and Netflix. And now here we are in this on the one hand, it's a Wild West. On the other hand, you have these massive corporate entities. My point about the reason I was framing this about the old networks was, we have this illusion that, it used to be you could really trust the New York Times and Dan Rather. And what that really meant was nobody could be heard disagreeing with the New York Times and Dan Rather. So if they decided on the narrative, and Brinkley and Huntley decided on the narrative, and Harry Reasoner decided on it, there were all these gatekeepers. Now we have the illusion of freedom, but you still have corporate gatekeepers in the form of Twitter and YouTube, who routinely censor information. Yeah. Let's talk about your proposals, because I'm going to first start out with your tweet. We don't have to hope that a benevolent person tries to buy a dominant platform, then hope they succeed in doing so, and then hope they enact free speech reforms. Really, really important point. It is scary to think, and as of this morning, we don't know if it's even really going to happen, or when, or what it's going to look like, but for Elon Musk who at the very least has changed the conversation and reframed the whole debate, that we might have been prisoners forever of this existing paradigm. We can adopt, you say, though, pro-speech protections and apply them to the digital town square. So you suggested a number of measures to reform Section 230, and I assume you know them by heart. So I'm not going to not make you read it off the screen, but I will cue you. First, you talk about a reforms to Section 230. What do you have in mind?
Well, you're right. I think, a lot of people have been really buoyant and happy about this announcement that Elon Musk is buying Twitter, and they're very hopeful that he's going to bend their content moderation policies towards a greater embrace of free expression. I'm among those. I'm also hopeful, but as you read there, I think we can do a whole heck of a lot more than just hope that this goes through. And who knows, every day there's a rumor it's going to go through, it's going to not. And then hope that if he does get it, he does in fact engage in these changes. We can use the authorities that we have to adopt pro-speech reform. And I think there's basically 5 core things that we have to do, and you can look at them different ways. But obviously, first is Section 230 reform. There's a lot of talk about misinformation. There's a lot of misinformation about Section 230 out there, so I'll try to break it down pretty cleanly and directly. There's one main provision, or one of the main provisions of Section 230 is 230C1, which basically says if you leave someone else's speech up on your website, you're not going to be liable if that speech turns out to be libelous or otherwise, illegal or unlawful. I think that's a great provision. It's a pro-speech provision. It lets people leave speech up. And everyone focuses on that portion of 230C1 that defends the status quo.
Exactly.
The problem, among others, is Section 230C2, which has been read by the courts, as Justice Thomas has explained, to give these same websites, websites or internet platforms, carte blanche to censor speech, not just with their First Amendment right and within the scope of that right, but with this statutory Section 230 right. And that's part of the problem. And courts blew all the doors off the limits that Congress put in 230C2, so that, again, now we're in a situation in which there's just carte blanche to censor. So I think the first thing we have to do is reform Section 230, largely keep C1, but take the thumb off the scale in favor of censorship. If you're going to censor, do so consistent with the scope of the First Amendment and its limits, but not the statutory right. That's one. But 230 reform is necessary. It's not sufficient. So I think we need a couple other things. We need some transparency. We need a total black box right now when it comes to social media. Why are things left up? Why are they taken down? Why do you gain followers? Why do you lose? At the FCC, for instance, when we repealed net neutrality in 2017, which people look at as the sine qua non of deregulation, we actually imposed transparency rules. So an ISP, an internet provider today, has to tell you, are they blocking? Are they throttling? What are they doing? Something like that should be applied to technology companies as well. Another component is accountability. So if you are taken down, you have some, appeal right, that there's a protection for pretextual takedown. So if they say, well, I'm not taking you down because of political speech, I'm taking you down for this reason, you should have the reason to challenge that. I think we need non-discrimination. There's no question that there's a First Amendment analysis that has to be done here because Twitter, Facebook, they themselves have First Amendment rights. But that doesn't mean we can't regulate their content moderation practices at all. And so I think we need to impose some anti-discrimination rules that would constrain that content moderation.
When you say discrimination, discrimination of what you mean, based on viewpoint, in other words?
Yeah, there's a couple of different ways that you could do it. Discrimination could simply be treat like cases alike. So if you're going to take down, a death threat directed at, a conservative, then you should take down a death threat directed at someone on the left. So an even-handed application is one version of non-discrimination. I think that we should go on another level, though, as well, which could be, political viewpoint, political affiliation. And there's some civil rights laws right now. In fact, DC, where the FCC is located, has a public accommodation law that says you can't kick someone out of your business based on their political party affiliation. Now, again, there's going to be a First Amendment challenge to this, but I think it's we have a fairly strong argument that we can make to do it. And then the last piece is user empowerment. Look, one of the stated purposes of 230 was to encourage these covered internet platforms to give users options to do their own content moderation. And I just think we've lost the balance of that. It's become a completely centralized system, or a largely centralized system, where Twitter or Facebook makes the decision. My view is let's let people decide. So for instance, you could have, a Fox News plugin, and that could filter your feed for you. Or you can do an MSNBC plugin, or you can get the Wild West plugin. I think that would be a good way to go, because a lot of people are trying to censor views. It's not just that they themselves don't want to hear an opposing view, which frankly, as a cultural matter, I think is a problem, but it goes well beyond that. It is that this idea should not exist. Even two consenting adults that want to exchange this idea should be barred from doing it. And so I think that's why user empowerment is good. I mean, this is not, as I say, this isn't Bird Box at the end of the day. We're not going to hold anybody's eyes open and force them to watch speech they don't want, but let's decentralize some of that, censorship or content moderation and re-empower people. So I think those are the 5 core things that we want to do. And I think it would address and resolve, a very substantial chunk of the problem that we have today.
Isn't it a phenomenal thing how media companies, which are basically brand names, hollowed out brand names that have transferred their brand equity to social media, have been so unabashed in attacking up and coming competition? Fox forget Fox, OAN, they brand them as extremist or off the wall. And it's this, I'll say this much for Coast. It's this rent-seeking inaction. It's just an extraordinary thing. They want to use government or whatever other institutions or regimes are available to them to prevent competition by even delegitimizing points of view and like categories of information. So someone comes on and says, we've got another way of looking at Russiagate, or we've got another way of looking at the election. We've got another way of looking at how to treat or prepare yourself or avoid COVID-19. They have succeeded in delegitimizing entire categories of speech. Now we have the Biden administration that wants to go beyond what their corporate proxies are doing already for them and put in a czar, a ministry of truth, in the guise of Homeland Security. I'm sure you've got thoughts on that.
I do. Well, it was actually 2 years ago, I wrote an op-ed for the Wall Street Journal that the theme of it was disinformation, in scare quotes or quotes, is the new disinformation. And what I meant by that has panned out exactly, which is people have realized that if they slap the label disinformation on political ideas or political viewpoints that they don't like, that they can dismiss them without having to talk about them on the merits. And this disinformation board that the Biden administration has set up, it's Orwellian, it's unconstitutional, it's un-American. The best time to shut that down was before they announced it. The second best time is right now. And there's been a lot of focus on the executive director and her prior tweets and social media videos. And I'll say, Ron, if you get that Mary Poppins song stuck in my head, our friendship is going to end right here. So I'm hoping we don't go there.
Okay, I will not go there. No screen share on that one.
Yeah, but the reality is, that's the wrong person for the job. But the more fundamental point is that job should not exist. And I'm hopeful that we get back to that point.
Well, isn't that an extraordinary thing? Is the idea of having such a job in the United States government is in and of itself so stunning. And yet the people who suggested it, is it tone deafness or is it just try and stop us to appoint somebody so obviously unsuited for exactly the reasons you would fear? What do you think is the move? What are they, I guess, again, do you think it's just a lack of understanding, or they want us to know that they know that we know and they don't care?
Yeah, it's a tough one to figure out what they're thinking there. I will say this. We've seen a spasm of censorship that, from my perspective, started, after the results of the 2016 election that accelerated during COVID-19 when we had this lockdown culture. Everyone was so scared, rightly so, of the virus. We want people to take the necessary precautions. We got to silence things that, are inconsistent with that. I think that just, led to this view of legitimizing, censorship, legitimizing the idea that you can shut down disinformation, but it's not good. I mean, for me, I look at this from the bookmarks of two speeches from one person, President Obama. In 2012, he gave a speech at the Palo Alto headquarters of Facebook, where he talked about the free flow of information over the internet being vital to a healthy democracy, as he said, 2012. Flash forward to just this year, and only a couple miles down the road at Stanford, President Obama gave a speech where he talked about the free flow of information on the internet being a threat to democracy. So vital to a healthy democracy, 2012, 2022, a threat to democracy. Well, what happened to result in such a massive pivot? And I would submit that what happened was the outcome of the 2016 election. And all of a sudden, this idea that the free flow of information doesn't produce outcomes at the ballot box that some people want is what has sort of led to this surge in censorship. So I think it's a cultural phenomenon that we have to push back on. I step back and I tell this story that the modern day op-ed launched on the pages of the New York Times in 1970, because the then editor, John Oakes, he gave a speech a little before that where he said, diversity of opinion is the lifeblood of democracy. The moment we insist that everyone think the same way we do, our democratic way of life is in jeopardy. You know, he wanted expressly views in the New York Times op-ed section that were divergent from those of the editors. And you flash forward now, and you got an op-ed in the New York Times, a year or two ago with Senator Cotton, and all of a sudden, there's a revolt inside the New York Times because it was an opinion that did exactly what John Oakes wanted to have happen. And the irony, of course, well, a lot of ironies, but one is that where the op-ed page was placed used to be where they held the obituaries, because it was a profit-making portion of the newspaper. And so it was, dead people, dead ideas replaced with lively ideas and divergent ideas. And all of a sudden, I guess it's making a 180 back to being a place that, only reflects the views that are consistent with the existing editors.
So now let's try to put ourselves in the shoes of people whose point of view is not the same as ours, and who are either libertarians or liberals who like how things are going, and who all of a sudden are sounding like libertarians, and they're saying, how could you possibly, Ron? You made your bones. We came to hear of you because of a free speech case that you won, and now here you are advocating for regulation. This is really regulation of private enterprise. This goes back obviously to something you said at the very beginning about, sort of libertarian approach that we had, where there was a tendency to trust corporate America. First of all, we see that corporate America has no problem operating against what should be its best commercial interests in order to push some kind of agenda, which I don't really quite understand. But what's the response to, how can you and Brendan and Ron be in favor of regulating private companies?
Yeah, I get this a lot. And the way I would think about it is, obviously there's two poles that are out there. On the one hand, you have sort of, fundamentalist libertarianism, who is the government to impose any regulation on any private entity? On the other hand, you have, heavy-handed, intrusive regulation. And my view is, there's a common sense place that we can find in the middle. I don't think the government should be making content moderation decisions. I don't think the government should be saying, this tweet up, this tweet out. I certainly don't think that the government should be doing what it appears the Biden administration is doing, which is going to social media companies and flagging posts and suggesting that they take it down. I think that, that veers towards the extreme of the government getting involved in content moderation. But I don't think that we should do nothing either. And that's why I think we can put some, basic common sense pro-speech guardrails in place. We've done it before. In the 1990s, for instance, when cable was just coming online, Congress stepped in because they decided that it was so vital that you be on the cable network to the economic viability of broadcasting, that they required cable providers to carry the local broadcast networks. That is a regime that takes a private entity and says, I know you wouldn't choose voluntarily to carry this channel, but I'm going to make you carry that channel for this broader, public interest purpose. And that's a rough analogy to where social media is today. Being on social media is so vital to, I think, sort of the public debate. It's where you have that blend of journalists, politicians, everyday Americans. Being there is so vital to participating in that public policy debate that I think we should similarly say, look, maybe you unfettered would choose not to carry this particular political speech, but we think there's such an interest in having that digital town square embrace free expression that we're going to limit your private right to exclude just a little bit. And again, they're going to raise a First Amendment argument, but I think that cable case, which went to the Supreme Court, Turner, and a handful of others are roughly analogous cases that can justify, relatively light touch regulations here.
I think what a lot of people forget is that we regulate almost everything. We are either give me the New Deal or roll back the New Deal. We live in a world in which every business, and not only businesses, but almost everything that people do in public is subject to regulation. So if you want to say, let it be different, that it should be different for a social media company because they're in the speech business, or as opposed to being in the lunch counter business or being in the garment business, where you're not free to hire whoever you want and you're not free to fire whoever you want. That strikes me as a very difficult distinction to rely on, because these are commercial businesses. They make money from advertising. What they actually do is invite consumers to come on to their platforms, to participate in their platforms, generate content without being paid as a general rule, in return for which that content, not in return for which, but that content is then used to entice advertisers with access to data and to eyeballs. That in and of itself is not speech. That's a business model where, just like in a bar, people come to sit down and not just to drink, but to meet with each other, to talk to each other. In other words, this is the analogy. This is the true analogy of the public square. Isn't just abstract ideas floating around. It's human beings interacting with each other, and someone finding a way to make a profit from that. Yeah. We do it all the time. We have historically done it. We've done it with newspapers. We've done it with, as you say, with radio, with TV. It is, and it is astonishing how, it's never astonishing, I guess nothing astonishes us anymore, but how quickly people change the views. I mean, I think as you noted, many of us who are much more oriented to libertarianism, growing up reading William F. Buckley, who was and Milton Friedman, we realize now that you have to recognize that corporate America, and this is, people made fun of Pat Buchanan talking about globalism in the 80s, but here we are. This is exactly what he was talking about.
Well, I think you're right. I mean, the manner in which a business operates is relevant, not just to the regulatory framework, but to the First Amendment analysis. And I've got a theory that I still have to finish writing up, and my team is on me to complete this law review article. But I think you can look at what are called compelled speech cases, the Supreme Court's cases, and put them on a continuum.
Right, so take a stop, because it's really important that non-lawyers understand what aspect of the First Amendment we're talking about here, which is the idea, which is to me a joke, that if the government gets involved in telling Twitter what it may not take down, then we're making Twitter carry messaging that is a form of compelled speech. Twitter wouldn't want to say that you could take hydrochloroquine. Twitter wouldn't want to say that Trump is an okay guy. And now you're making Twitter say that. Okay.
Yeah, you're right. You start with the baseline proposition that, the government cannot regulate a private entity's decision to exclude, whether that's, things or speech. So you start there. But, that's not where the First Amendment case law has come down. So on the one end of the spectrum, I would give you a case, which you probably know, Miami Herald versus Tornillo, which is basically a case where Florida tried to force a newspaper to run, opposing editorials when they didn't want to. And the Supreme Court said, no, you can't do that. You can't tell a private entity what speech to carry or not. And a lot of people that say you can't regulate content moderation point to that case. Well, that's an extreme case as a factual matter. On the other end of the spectrum, you've got cases like the telephone network, right? A common carriage case where, we have rules at the FCC that prohibit you from, refusing to hook up a customer or refusing to carry speech because of its content. So what distinguishes this spectrum? On the one hand, it is how much of your business is a conduit for the speech of other people. A newspaper is not a conduit for other people's speech. It is the newspaper's own speech. They select every single word. Their own people write every single word. That's not how social media operates. Twitter has a Twitter handle @Twitter, and we're not saying that the @Twitter account needs to write stuff that they don't believe. They can continue to fully express their view without ever impinging on Twitter's right to speak. What we're saying is, in the main, you're operating as a conduit for other people's speech. And when you do so, I think that changes the First Amendment analysis. Again, you've got the telephone case on one end, you've got 2015, 2016, when the Obama administration adopted net neutrality rules on the internet. The DC Circuit upheld that against a First Amendment challenge. And again, said basically, look, you're a conduit for other people's speech. You're not the newspaper. Again, I think the cable case is somewhere in there as well. And so,
well, you know what else I would suggest to you?
Herald.
When you're writing your law review article, you can cite you can cite to my case, Mattel versus Tam, where the government said, if we have to register the slants and other disparaging, as we deem it, disparaging trademarks, that's compelled speech on the government. Right. And the court said, Justice Alito said, first of all, who says the government has a First Amendment right not to have its speech compelled? And number two, what are you talking about? Nobody believes that you believe every message of every trademark that's on the National Register. It's simply a register of trademarks. It's not speech. It is a conduit. It is a place for people to find out what are trademarks that people are claiming to have. Even having a trademark registration doesn't in and of itself guarantee that you have the right. It means that you're claiming you have the right. So people, so that's the compelled speech point. Isn't there another First Amendment argument? I guess it's more, no, it's not really a First Amendment argument. It's more the private enterprise argument, which is not in and of itself a constitutional argument because of what we've done to the Commerce Clause, right? I mean, there's anything Congress can regulate is now, in theory, I mean, and no one really seems to know where the line is, but in theory is a subject of congressional regulation. In other words, Congress can regulate it by definition. That's what Section 230 is. I mean, right, exactly.
We have Section 230 today, so that's sort of the best evidence that Congress can presumably lawfully regulate content moderation. But now, obviously, we're seeing some state law efforts as well. Florida, Texas. I do think the interstate commerce component, 230 preemption could be an interesting component of those cases. As we're speaking now, at least, the Fifth Circuit reversed the stay of the Texas social media law, so that will be going into effect. And so I do think that, notwithstanding the fact that there'll be some Commerce Clause related and preemption related arguments, that state legislatures should step forward, because we're having a challenge at the federal level right now, because Republicans and Democrats, they both want to reform social media, but they're sort of pulling on opposite ends of the same thread. Republicans tend to want less censorship. I would say Democrats tend to want more censorship, what they would call hateful speech or disinformation. That's their perspective. But yeah,
I mean, I have written. You've heard me. If you ever really look at Twitter, you couldn't have avoided this. Will Chamberlain and I wrote an article a couple of years ago about how really you can really frame it as a consumer protection issue. And again, users on Twitter are the product, not the customer. And if you're going to induce consumers to come onto your social media platform, whether it's Twitter or Facebook or Google, build up a business that can be worth many millions of dollars to you in terms of revenue and in terms of brand building, and then arbitrarily and capriciously, terms that go to administrative law and government, not to not to private entities, but for no reason at all, yank you off the platform with no recourse whatsoever. It's first of all hard to imagine that Congress had that intention when it enacted 230, as you say in your, the short preface that you put up, about your proposals. And number two, why are consumers any less entitled to the protection from that kind of abuse by social media companies that have benefited from the content and from the interactions that people have donated to them in exchange for access to their platform without any recourse? It's, I think to me, the Federal Trade Commission Act and the little FTC Acts of the various states also provides authority for this kind of regulation, or even existing enforcement.
Yeah, I think this is why I think the transparency, accountability 1-2 punch is so important. I think we should be requiring, to the extent that it doesn't already, clear terms of service. Because to your point, people are building businesses on these platforms, and there's no business in this country that we would allow to say, hey, I'm selling you product X, and then all of a sudden, bam, it's gone, and it's product Y or a bait and switch. So I think we should be transparent about what you do, and then let's hold you accountable to that, just like we would, Joe the plumber or any other business. There's an element of this that is not about speech or First Amendment. It is about conduct and operating consistent with the business model that has induced people to invest in your platform.
So much to talk about, Brendan. Thank you so much for taking time to join us. You usually I've got guests who are pushing a book or a new documentary. You work for the FCC. You're pushing ideas. How much longer is your term as commissioner?
I got a couple years left. There's 5 FCC commissioners generally, and each of us sort of have our term roll up, one of us a year. So I got a little bit of time left.
Good. Well, I'm sure you're going to use it very well. And I think you're a very important advocate for clear thinking about this. And you have the perspective of someone who really understands these analogies to broadcasting and to regulation. So I'm looking forward to, remaining in touch with you, and hopefully, we'll have another conversation about this as things develop.
Thanks. Appreciate it. Thanks, Ron.
Thank you very much for coming on.